Happy Friday, happy Friday, happy Friday, everybody. I'm a little jet lagged from a red eye from the West Coast. So if I go in all kinds of different directions, it'll be pretty much what I usually do anyway. So I'm delighted to have with me, however, people who are hopefully not jet lagged. Amy Stepanovich, our head of U.S. policy, Gabriela Zanfer-Fortuna, our global lead, and Stacy Gray, our deputy U.S. lead, and wise people all. We are today catching up on some of the top things that happened this week. And wow, there were top things happening. The mega news, perhaps not unexpected. It's surprising sometimes these things create like a bombshell. We all understood that the EDPB had ordered the DPC to, update its proposed decision. We saw the DPC's reply to that, update saying they disagreed, but of course they'll, participate in this process and go ahead. So I guess it was really just a matter of the timing and maybe some leaks about the size of the fine. So Gabriela and I will come back to this because the coverage, of course, is Facebook, Meta, and it is, of course, a decision about Facebook and Meta. But for lawyers, in most legal systems, we look at precedent. When a regulator or here the FTC or another commissioner takes an action, we say, well, this is the law and it's applicable to me, to you, to other organizations. So the interesting question for us is, did the Europeans just formally, by this decision, come to the conclusion, not a surprising conclusion, again, we know the court case, we know the ECG decision. Did we come to the conclusion that data flows to US, data flows to most of the countries in Africa, most of the non-adequate countries of the world, should stop on Monday, lest you also risk that mega fine? I suspect some of us will say, no, it's just about Facebook. Well, okay, so if some complaints were filed against 100, 200, 300 other universities, not-for-profits, governments, Deutsche Bank, every organization. Anyway, we will come to it. But first, let's wrap up and talk about some of the U.S. activities as we then come back to discuss what is expected to be a Monday announcement. Monday announcement about both a fine and potentially an order to stop data flows. Does this mean you won't be able to use WhatsApp in Europe, or that I won't be able to Facebook with my dear friends? Or what are we on now? Oh, we are on StreamYard, we're on LinkedIn. Well, the decision isn't against them, but why would it not be applicable? So if this is farewell to our European colleagues, farewell. But let's first wrap up the US before Gabriela helps us understand whether or not this is it and this is farewell for international data exchanges. We'll come back to it. Any of our friends in Europe or around the world who are following this decision, get ready to chime in because we'll get a little spicy here. Stacy, Amy, FTC had an open meeting. For those who are not FTC geeks, wearing my IAPP privacy geek t-shirt here today, kind of like that. The FTC has been holding open meetings, which is unusual. Usually these meetings are not open and there's candid discussion and so forth. But the chair, in her plan to be more transparent, I suppose, has been holding these open meetings. The downside is that the kind of discussion that you might expect between the commissioners and the behind the scenes type stuff, well, I guess doesn't happen there. Maybe that's for the best. Maybe it's not. But we get a much more structured, show, display, formal announcements, and we get people being able to show up and yell and say what they please. So it's very different. What happened this week? There was an open commission meeting. There are some new items on the agenda. We've got some insights into what's happening at the FTC as a result of this open commission meeting.
Yeah, so for those who aren't geeks with the official t-shirt, Jules, this was the FTC's monthly meeting. Most months, they just are doing procedural things that are not necessarily of making major news. But this month was actually pretty significant. And as a result, it actually had quite a bit of public commentary as well. So the two things that were significant about yesterday's meeting were One, the commission has decided on a unanimous 3-0 vote that they're going to begin a notice of proposed rulemaking on the health breach notification rule. That's kind of in line with trends in the United States to better protect non-HIPAA health data. So outside of the medical records, doctor-patient context, if you have a health-related app, service, product, this is one you really want to be paying attention to. It looks like the main reason for this new rulemaking is going to be to clarify some of the expansions that the FTC has done with case law recently, or case enforcements recently, that a breach of health data is not limited to just hackers and security vulnerabilities, that a breach of non-HIPAA health data under the HBNR includes any inappropriate disclosure. So that means sharing with your third-party ad tech company, sharing with Google Analytics, sharing in ways that consumers are not aware of or did not consent to. So big deal for them to get that into law. And we've seen the trend of the last couple of cases over the last couple of months showing that.
Stacey, on this note, so the Congress gave the FTC this non-HIPAA health data breach notification, and it clearly was worded when they passed this law, and the early FTC description of who was covered, it was medical records that weren't covered by HIPAA because maybe you downloaded them into an app, but it clearly was medical records. And
Yeah.
the FTC made like this statement, or they updated an FAQ. I forgot exactly what they did. And they said, oh no, it could be, and a lot of industry was like, whoa, wait, that's not what it is. So is this a clarification, or are they now just building, what's going on there?
It's a great question. Yeah, so the core use case, like the paradigm of this would be if you go and you take your medical records from your provider and bring it somewhere else into the consumer space. Like if I take my prescription for my glasses from my doctor and then upload it to a commercial entity like Warby Parker because I want to order a new pair of glasses, that's a health record, but it's been removed from the HIPAA context. So that's kind of the paradigm. And this is an extension of that, or a clarification. This is probably why the FTC feels they need to document this in rules rather than just doing it through enforcement.
They basically said it was like any fitness app. Like the proposed scope seemed vast and just surprising, because that's not what HIPAA or health data breach lawyers thought that meant.
So they did it in GoodRx, where it was in fact pharmaceutical prescriptions. They chose not to do it in BetterHelp, which didn't involve similar information. And then the one that came out this week, not related to the open meeting, but just another enforcement settlement that dropped this week against an app called Pre-Mom, which is a pregnancy tracking app, involved not prescription or medical record data, but still what you might consider a little bit more serious health records. So uploading an ovulation kit photo, for example, into the app. So they're not expanding the reach to include the world of absolutely everything that could be health data, but they are expanding it from what the traditional paradigm was. And they're expanding the definition of breach to include any disclosure that the individual did not consent to, wasn't aware of. So yeah, big deal. And those rules will come out presumably over the next couple of years.
Amy?
Yeah, I think it's interesting that we're seeing more recognition of the, data breach has typically been thought of as a security issue. This is what happens when you do bad on security, information gets leaked. And we're seeing more recognition that there's a privacy component here, and like almost a shift with this expansion into that privacy world and not purely security. I think that's really fascinating, and something we should be on the lookout for is a further expansion of those, or conflagration. Oh my goodness, Friday afternoon brain of those two concepts. I also want to, like Stacey mentioned, the two statements yesterday were approved 3-0. And the reason they were approved 3-0 is we are still lacking Republican representation on the FTC. which I think is important to keep noting, no matter what political affiliation you are. I think having a government that has people who are going to dissent makes everybody stronger. You get arguments that you have to stand up against. You get dissenting opinions that people can read and understand what's on the other side. And now we're really not seeing that, which is unfortunate. And I'm hoping that we'll see a couple nominations there soon. We did see this week the announcement of a nomination to fill the vacant spot on the FCC, the Federal Communications Commission, with Ana Gomez being put as the likely nominee to fill the slot that would have been had Gigi Sohn been confirmed and not withdrawn her candidacy from that role. Maybe we'll see FTC commissioners put up soon. We'll have to wait.
What else this week? FTC.
That wasn't even the end of the FTC announcements.
Oh, more FTC. Yes.
The other very important thing they did also by a 3-0 unanimous vote was issue a policy statement on biometric information. So big deal. For those who watch carefully, the FTC has only brought maybe a handful, one or two significant enforcement actions on specifically biometric data and facial recognition in particular. So this was very timely, and I think if we sort of follow what we saw in the non-HIPAA health space, we can predict that we will see a significant number of investigations and enforcement actions coming in the next year around biometrics and specifically facial recognition. So it's just a policy statement. It doesn't have the binding force of law like a rule, but it lays out how the FTC thinks about biometric information under their existing, very old, longstanding deception and unfairness authority under Section 5.
Be interesting to look at that and see what they capture compared to like BIPA and Jameson, who leads our AR/VR work, has been noting how some of the body information may or may not always be a biometric. When is it simply your temperature or the shape of an eye versus a unique identifier? Or
it is interesting, and from my first glance, I would say they're going to tend towards interpreting fairly broadly. One of the examples that the policy statement puts out there is that in the context of facial recognition, both a photograph and a template based on that photograph are considered biometric information. So photographs are typically exempted from state laws like BIPA, mostly for practical reasons. There would just be a whole lot of procedural issues to deal with things like, yearbooks and photo storage libraries. But so that seems to be a progression, and it's body-based information. So the policy statement doesn't directly address this, but some of the questions I have would be around things like eye tracking or where your hands or your body is in space in a virtual reality setting, for example. Really, really interesting. And I think when there's enough data there that you could identify someone in another context, you're likely looking at a biometric. Where exactly you draw those lines, I don't know, but it is the FTC, of course. They do tend to start with scrutinizing the most egregious cases. And they've done something really helpful here, which is put out a list of the specific kinds of things that they're going to be targeting. And many of them are around lack of training, lack of third-party due diligence, and accuracy claims. If you're making any accuracy claims about how accurate your biometric information or your biometric tool is as a vendor, they better be correct. They better be truthful, and they better not reflect, for example, the accuracy of a facial recognition tool in a laboratory setting where the pictures are perfect. This is one of the things Commissioner Bedoya pointed out, which is not reflective of how the tool is going to be used in the real world, where the pictures might be grainy.
And that's very consistent with what they've been saying about AI and accuracy. Facial recognition obviously is an AI-based tool, but in their statement on AI leaning on their traditional authorities, representing that something works as you intended is just consumer protection law, 101.
Yeah, that's just Section 5 basics. So this is very consistent with that, and it's very heavily documented with plenty of footnotes. So I think lawyers are going to be very happy with this one.
Quick side note: our friend and superstar privacy lawyer John Neiditz points out that even in a traditional HIPAA breach, non-health data is covered to the extent that it's data that links you to a provider, even though it's not medical information. So, interesting note. I do think, broadening to the extent that a fitness app or even that nature is covered, but I guess consistent in that regard. We should note that Premom was initially identified by the IDAC, the International Digital Accountability Council, a not-for-profit chaired by yours truly, that was created to try to, I'd say, self-police the app ecosystem, arguing that if we want people to be able to trust apps, and we want regulators to have trust that the ecosystem isn't a Wild West. Obviously, there's enforcement that the FTC can do, but there's only so much of that. We said, where is the white hat, guard supported by platforms, supported by companies, that is finding these things in advance and stopping them before everything becomes a problem or an enforcement? Hasn't perfectly worked out in that there hasn't been a huge appetite for that, but the IDAC has been out there doing some of this work to kind of prove the case. And this was an example of an app that they ran their technical tools and identified data going to some very strange places. There was a big Washington Post story, and obviously the FTC followed up on that. So useful to note. Amy, you were going to touch a bit on some of the EEOC and state laws.
Yeah, Stacy brought up AI, which I don't think you can talk about privacy news of the week without touching on AI and the U.S. Equal Employment Opportunity Commission. Sometimes I get so wrapped up in acronyms I forget what they stand for. The EEOC put out guidance today on the use of AI in specifically hiring, promotion, and firing, termination of employment, which I think is going to be really fascinating. They say it's mostly a restatement of what has come before, but definitely something that people should look at, especially in the new age of generative AI, which has been taking over this year. That was the #1 topic in any press that I read this week on the topic of privacy. It just keeps coming up. So going to definitely be paying attention to that. And then as our very tired U.S. legislation team can tell you, there is still action at the state level on comprehensive and less comprehensive privacy laws. And I think 2 things to be watching this week and beyond. One is that we have what is ostensibly, arguably, a comprehensive privacy law out of Florida that we're waiting for the governor to sign. So our dear friend Stacey Gray might be getting privacy rights soon, but it really applies fairly narrowly from a privacy perspective, and actually has a incredibly broad age-appropriate design code that they've picked up and modeled off of California, but made somehow both more broad and more narrow. So people should be paying attention to that. And then Texas is moving forward. Actually, I think just this week went to conference committee with a comprehensive privacy law. Headlines are calling this the strongest U.S. privacy law in the country. Definitely something to be paying attention to. But one of the versions, the Texas Senate version of the law, removes sexual orientation from the list of sensitive data entitled to protection. So they're trying to remove that category of sensitive information from the law. And we'll have to see what comes out of the conference committee to see what final version heads to the governor's desk in Texas. And it would be really unfortunate if what people in the news are calling the strongest privacy law in the country doesn't recognize sexual orientation as a sensitive category of information. I am hopeful that we will see a positive development in conference. I'm hopeful might be too strong of a word. I'm rooting that we will see that come back from the conference committee.
Oh, I can't wait to see what Governor DeSantis and the Florida AG believe is in the best interests of the child as well. The big tragedy of this rush to state privacy legislation has been folks who I think should understand how some of these are going to be used as best interests of the child, given the views today of trying to limit transgender discussion, trying to limit discussion of racism. We got to advance privacy legislation, but I think we need to be well attuned to the fact that we're not solely about privacy legislation, right? As our European colleagues have well structured their framing of the GDPR, it's about rights and freedoms of the individual. The reason we are looking to protect privacy is not just because some of you really want to live, under a rock. Yes, you should have those rights. You should be able to live on a mountain, live in the wilderness, see nobody, opt out of all things. Yes, but we really care about this and devote our time and energy to it because we recognize that these tools are what power and control and competition and relationships between different structures in society. It's arbitrated by how and who and where we have data about each other. So let's not lose sight of what we're trying to do here for the sake of important privacy rules. We need to recognize that we're looking to balance the rights and freedoms of individuals, and we shouldn't sell one short at the expense of the other. We're gonna jump into the big European news, but we'll come back to some of the other US stuff if folks want to flag anything we missed. One quick thing that we can't, however, forget: the big AI hearing, the big hearing by the Privacy and Technology Subcommittee of Commerce, Sam Altman testifying, calling for regulation, calling for a new agency. I think we agree, regulation. But as Gabriela has sort of long pointed out, the GDPR is already an AI regulation. She and her team did a big study on all the automatic decisions that exist and the enforcements that exist in Europe already. And again, we'll have an AI Act on top of it, but we're ignoring the fact that the first line of defense, the first line of structure for regulating AI is data protection. Doesn't solve all the problems, doesn't solve maybe most of the problems, but to the extent that much of this is built on personal information, it is the initial gatekeeper, and we have vehicles. So Congress, do data protection legislation, and you will at least start forcing data protection assessments, risk assessments, giving people rights to delete, explanation. I mean, we've got the tools. Let's not reinvent new things or new agencies. Lena Khan wants to do it. She's fierce. She's moving forward. She has said, our agency regulates AI. The Biden administration has ordered all the other agencies, EOC, HUD, move on AI. Deirdre Mulligan, prominent, preeminent academic at Berkeley, now deputy CTO at the White House, working privacy, AI. So Altman called for a new agency. It takes years. How long did it take to set up the CFPB? Years. We kick this can down the road when we can act on it now. Okay. Big news. We expect on Monday this decision. Gabriela, you want to give us a bit of the detail and we can talk about whether the world will end or...
Yes, absolutely. Thank you. But actually, let me start with the biggest news of the week in Europe, which is that we launched our data protection by design and by default report. And that's a great overview of case law, about 90 plus cases that have been summarized, synthesized, analyzed for you to get lessons from that enforcement. So please check it out. Now, other than that, indeed, this week, we have seen a couple of media reports in Bloomberg and Politico, at least, announcing that on Monday, we will finally have the decision in the Meta case from DPC Ireland, the case related to international data transfers. And this is the very, very long saga that has started many years ago. I lost count already with the Schrems cases. And the decision has been going through a lot of the procedural mill in Europe. The EDPB saw a draft of it. They voted to make some changes there. They sent it back to the Irish DPC. And then on Monday, we will see the final decision that published. So everybody is curious about that. Now, the information that transpired is that the decision will include possibly the biggest GDPR fine on record. Right now, the record is held at about 750 million euros in a case against Amazon for a couple of years back. And also a decision to suspend data transfers from Europe to the United States done by Facebook through the Facebook service only. So not, my understanding from the report is not all of the Meta services would be included here, but just the Facebook service. However, let's look at the decision, before being certain about that. And this is the part that's actually, quite impactful, because if indeed there is no possible way to rely on standard contractual clauses plus the additional technical measures that we know that companies have been putting on top of their clauses to actually send data from Europe to the US. Now, what does that mean? Ultimately, the big concern here is actually the national security framework. It's not something that's in the hands of companies, unless some very extreme measures of data localization, which I don't think is a good solution to think about. So I think the consequences will be extraordinary if this legal interpretation will be, let's say, propagated in the other cases. And frankly, I don't know where this will leave the data flows from Europe to the US in so many other contexts as well, not only related to social media.
Or Europe to anywhere outside the adequate country.
Yes, where we will not have an adequacy decision with other countries. Everybody is relying on standard contractual clauses, to send data to India, for example, or to Brazil, or to any of the other big economies out there. They don't have an adequacy decision. Who is going to assess, the national security practices? Will there be any sort of technical and organizational measures that will be enough to be sending data over there? So I'm not really sure that the enormity of the possible consequences has been grasped. But I'm also curious to hear your thoughts, Jules.
Well, here's what's frustrating. The discussion is going to be about the size of the fine and about Facebook. And I get it, right? The complaint is against them. It is only binding on them. Because when I raised with some of my colleagues in Europe, so, well, no, it's a decision binding on Facebook. I'm like, but we're interested in the rule of law here. So isn't it the case that a wide swath of people, certainly Amy's got a lot of expertise in FISA. We'll have her comment on this in a moment, but certainly anybody subject to FISA. Or we had a discussion with Lori Baker recently, and she and her privacy authority did an assessment in an honest way. She said, which countries don't have protections that would meet something like the Schrems standard? And they rated red and yellow a wide range of countries. And what they did, interestingly and honestly, is they said, well, there may also be countries that are technically, with law on the books, but is there actually a way to go to court? Is there really a reality of being able to trust the legal process in those countries? And so if one is honestly taking the effects of this decision, data flows come to a halt. And, a number of months ago, Facebook warned in its SEC filing that it might have to terminate moving data, and it could impact services. And people say, oh, they're threatening. I'm like, it's an SEC filing. You have to actually disclose real risks. One of our friends in social media looked at the filings of many other companies And indeed, in recent months, because of this situation, a number of leading companies have said, we need to disclose that there is legal risk because of this current situation that we would have to limit or not. Now, here's what's going to happen. And what I don't like is that it ends up breeding disrespect with senior executives for data protection law, right? All the executives of the world are going to read this decision and say, does this apply to us? And their legal people and their chief privacy officers and DPOs are going to say, yes, yes. But it's against Facebook. And there isn't a complaint filed against us. And we're hoping that there'll be a EU-US agreement. And for all of our activities that are not through the US, we just don't think that anybody cares about really holding other countries or other companies accountable. And that's really making a mockery of the legal system. And that's why I really feel like we're in this very disappointing place where there is clearly a policy breakdown, a legal breakdown, and where we do really need, and we will have, despite the opposition of the parliament and their vote recently and the Libe committee, we expect, of course, that the European Commission, their proposal will be, we predict, ratified by the European Council, and we will have an arrangement, but it's only EU-US. And it's a significant arrangement. And people are critiquing whether the judges are the right kind of judges or official judges. It's landmark based on what we see almost anywhere else in the world. We're being so EU-US centric, and we're not thinking about what this means for Africa, what this means for South America, what this means for such a wide range. Anyway, very frustrating. Amy, let me ask you this. Obviously, FISA is one of the drivers. Legislatively, FISA is up for renewal. These things used to be rubber stamped because who wasn't for law and order? Certainly the Democrats were, maybe, usually, mostly. They worried about surveillance, but in the end, went along with the goals of the national security community. The Republicans were usually guaranteed, of course. Well, some of the leaders on each side are not as comfortable anymore, skeptical, critical of the FBI. You see a big Republican sort of debate that the FBI was doing this and doing that. What do you see happening with 702 reform? Is it possible that any changes can be made? Seems like the appetite is mostly for U.S. surveillance changes. What's happening?
Yeah, so 702 and the FISA Amendments Act generally are about surveillance of non-U.S. persons in the U.S. And oddly enough, what we're going to see when Europeans' data is taken out of the U.S. is a lot more surveillance of EU person data, because the agencies conducting the surveillance can say, well, it's not here. We don't have to even follow the very, very generous provisions of 702. We're now throwing it under Executive Order 12333, which is a Reagan-era executive order. And my very simplified version is that it basically says, do anything that's not otherwise illegal or unconstitutional. So we're putting, from a national security perspective, even when we're looking at surveillance as the reason to not allow data in the US, we're making it more subject to surveillance by putting it outside of the US. And I think it's kind of critical this year as we look at 702 and the FAA renewal process. It expires in December. The last time we revisited it, it was arguably expanded to allow for more surveillance. I would love to see more companies, more government officials from around the world, from the EU and beyond, weighing in. We should probably see some international processes around what should surveillance look like internationally, from countries to other people, to quote unquote foreigners of that country. Because until we get norms and broadly recommended and accepted standards for that, we're in a place where a lot of people are accusing the EU of being hypocritical because they conduct the same surveillance. We're using surveillance as a basis to make EU people more susceptible to surveillance. And we're shutting down data transfers, which arguably is bad for human rights. It's bad for the economy. It's bad for cybersecurity. There's no way that this is necessarily good for anybody. So lot to unpack there, but this is really the year if people want to weigh into the legislative process and see if we can get any changes and make this better for people.
And note Amy's point, it's expiring. So it's not one of these things where, will Congress act? Well, Congress won't act, because Congress won't act on anything, but it expires. So there will be an acting, and either you renew it exactly the way it is, or you make changes. So this is a forcing question. Forcing questions don't seem to solve things. Evidently, we're going to default on our, on our debt payments because of, and the sky is going to fall in because we can't agree on these issues. So who knows? Osborne's Emily Barwell, a fabulous lawyer and friend of ours, points out that a lot of organizations, even when the agreement is in place, may not rush back into the shield or the safe harbor. But the reason you care about this, even if you're not in the safe harbor or want to be in the safe harbor, is it provides the protections that the SCCs need to be able to be valid, because otherwise we know that there aren't safeguards that are adequate enough. So the importance is the protections for these human rights that are provided that now allow you to use SCCs. Obviously, there are people who need to go back into safe harbor because they need employee data covered. There's some real, solving of friction. But of course, this would only cover a very limited set of data flows. Our friend Angelique says, well, is this really going to happen? There'll be a decision. Facebook, I guess, gets to appeal it. And then if the council approves the Europe to US, I guess that's covered. Note, of course, that data moves elsewhere in the world, like we said. So we're being all of these discussions end up being so EU-US centric, and as an organization that is active globally. And remember, this is not just about corporate entities. This is about universities, not-for-profits, and so forth. So yes, I suspect that we'll have the decision before. I don't know that that helps Facebook in terms of the fine, which also a bit odd, evidently is being calculated not from but from the inception of these transfers. Is that, Gabrielle, is that right? There was some discussion I was seeing about well, I guess we don't know, we don't know anything.
Need to look at the decision exactly, but everyone's understanding is that this will impact the transfers that happened after the invalidation of the privacy shield, when the lawful ground for transfers was switched to standard contractual clauses. So there will be a lot of reading of that decision on Monday, so we can understand exactly the reasoning and the impacts. And I do agree with Angelique that we are expecting an adequacy decision soon. However, we don't know how soon. There are a couple of outstanding issues that would need to be solved. The first one among which is that the US government needs to designate the countries in the European Union as being qualifying countries for their citizens to be able to have access to the redress system here in the US that's being created.
Gabriella, is it possible we might leave out one or two to make a... I bet you we don't. We'll do all. But wouldn't it be maybe interesting point to take a look at one or two of the countries in Europe that are having some troubles right now with rule of law and human rights, or Hungary, and make a point. Now, maybe the Europeans wouldn't like that, and it's a full deal or no deal. Maybe they'll want to leave out Texas, or like California seems to be getting admitted to.
Florida.
So this won't happen. But you know what? It might be interesting to have some commentary in the agreement that we'll monitor carefully what's going on in a couple of countries, as there will be a lot of language about monitoring the process in the US. Will the executive order be changed or repealed. There'll be lots of sort of, we'll check back every certain amount of time as a way of assuring. Maybe there should be some mutuality in that as well.
Well, it's definitely interesting to look at that, because the assessment will be done on the specific national security system of a country that's member of the European Union, because there's no common national security system type of framework in the EU. The EU does not have competence on national security. So therefore, my understanding is that each of the country's systems must be assessed. And we have not yet seen that designation. If anyone here among our friends has information about that, please comment. Let us know.
Who's doing that? Is it like a DOJ is doing it?
I think the DOJ. I am not 100% certain, but that's my recollection.
Well, DOJ people, go look at Laurie Baker at Dubai's assessment. It's a good place to start. And there have been a few processes, I think, that have tried to look at some of the different oversight systems in a number of countries. And by the way, if anybody has ever filed anything in any of those countries, which in theory have a process where you can go to court and learn and so on and so forth, we are eager to hear that there is actually a functioning process. Obviously, there have been some court cases where national laws have been struck down, but the argument that there is a serious individual redress system that would be, that works powerfully and effectively, I think has been one of these, maybe in theory more than in practice, laws. Anyway, what have we missed? We are coming up. We try not to spend the whole hour with you. People are at work and doing stuff, and we want to keep you interested in seeing us instead of wearing out our welcome. Any other big thing, either folks in the community that are listening, or any of you, anything that we didn't flag that is worthy? Gabriela.
I have a big thing, which is about next week, actually, when the CPDP conference in Brussels takes place. And if you will be there, come say hi. Our director for Europe, Rob Van Eyck, will be there. I'll be there as well for a couple of panels. Christina Michalakaki, our fellow, and Katerina Demetu, our policy council, will all be there. So please join us at CPDP.
And let me just flag, have we posted the data protection by design and data protection by default report? I think or we're releasing it next week?
It was posted on Wednesday, and we will have a panel to release it at CPDP together with the community, and answer questions and continue the conversation.
So let me commend it to your attention. Article 25 has been a mystery to me for a long time in trying to understand whether this was advice. Is this enforcement? Can you be guilty of not doing an appropriate PETs or an appropriate data protection by design if you're also not already violating GDPR? Is this simply guidance? Well, the team took a look at how many cases where you saw actual enforcement?
160 cases overall, but then we stopped at 92 because some of them were just mentioning Article 25 without any assessment. So we analyzed the ones that could be analyzed, but it's still a significant number, I would say, and a lot of lessons. The jury is still out there on the effectiveness of the article. However, it has been heavily used, and actually the trend seems to be that it's more and more being relied on, including, for those of you who paid attention, in the recent ChatGPT order from the Garante, Article 25 was actually mentioned among the grounds on the basis of which the order was given.
Yeah, interesting. Is it thrown in when there's other enforcement activity, or is it indeed as statute implies, something you can violate itself, perhaps without violating actual law because you didn't do enough to live up to these principles? Okay. Hey, everybody. Thank you. Thanks, Gabriela, Amy, and Stacy for joining. And please do take a look at the report if this is someplace you want to dive into. And we look forward to joining you again next Friday and every Friday afterwards at noon Eastern. So please do tune in. Occasionally, if we have a VIP European guest, we pull it up a little bit closer to the morning so that our European colleagues don't have to do this over a cocktail late in the day. But always on Friday. Thanks all. Good to see you. Have a good weekend, everybody.
Happy weekend.
Thanks for comments from all of you.